Last week on Don't Talk TV, I started what I've termed a trilogy, looking at how hate crime laws are applied in this country and how, in my view, they're applied unequally. And in my view, people of European heritage in Canada are held to a higher standard, are more likely to be charged than those of other backgrounds. In part two today, I want to take a look specifically at one case that caught my attention. It came up in 2020, that of Travis Patron or Patron. I'm still not sure how to pronounce his name, the erstwhile leader of the Canadian Nationalist Party. He was, earlier this year, had his appeal quashed, where he sought to appeal his conviction. So I want to look a bit at what happened there and discuss that a bit more. I initially discussed his case in episode 16 of Don't Talk TV, and I highly recommend that viewers go back and watch that. And don't forget to like, share, and subscribe. If we make it to 10,000 subscribers on YouTube by the end of 2023, I will grow my handlebar mustache back. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Several years ago, an individual named Travis Patron or Patron made a video called, quote, "Beware the Parasitic Tribe," unquote. I covered this in more detail in episode 16, but let me just give you a short snippet of what he said.
Everywhere these people go, they infiltrate the media, they hijack the central bank, and they infect the body politic like a parasite. If they had their way, our entire way of life would be eradicated. They don't like us. In fact, That was just part of a longer video. He was ultimately charged. The Canadian Anti-Hate Network filed a complaint. The RCMP investigated this and eventually charged him. Back when I made episode 16, I suggested a number of potential defenses or reasons why I thought a conviction was in doubt, but unfortunately, Mr. Patron chose not to approach the case from the sort of direction that I would have approached it from, and was ultimately convicted. So today, I want to look firstly at his sovereign citizen, freeman on the land defense, and why that was completely shot down. And in fact, the case is actually a good one for showing how these arguments never ever work. A lot of these sovereign citizen types, they, quite frankly, in my view, lie and tell people that they've won in court when they actually don't. They never do. So look at that. And then we will look at the rest of the decision as it related to the hate crime provisions of the code. And we'll talk a little bit about his sentence and some of my thoughts, again, on how I think he could have or should have been acquitted if this case was approached in the correct way, in my view. So here we have the decision from Canley. Link is in the show description as always. Her Majesty the Queen and Travis Patron. So this is a pretrial application decision. Mr. Patron, in my view, made not the wisest decision ever to go with a jury trial. I think this is a highly legal case, but we'll talk about that later. So he filed a couple of applications. One of them relied on Magna Carta. The other application challenged the constitutionality of Section 319 of the Criminal Code, which, as I discussed in episode 16, had already been ruled on by the Supreme Court in Her Majesty the Queen and Keegstra. But let's look at this sovereign citizen type argument from the Magna Carta. So he wrote by hand his own thing, and essentially, I think this is the crux of his argument here, where he says, Magna Carta is lawfully binding on the Crown after being invoked on March 23rd, 2001. Not sure what that's in reference to. Magna Carta was obviously from 1215, as he does mention after that. And he says that this great charter confirms that the English Church shall be free, and shall have its rights undiminished, and its liberties unimpaired, a desire born of the Crown's own free will. And he said, no longer will our constituency, the Canadian Nationalist Party, suffer itself to be under the whore of Babylon. And in accordance with Section 6A, sub 2
Travis Patron hereby solemnly declares his lawful notice issued on Her Majesty the Queen, with God as his witness, under the sig of the circle twice cut, and in the name of justice. Sovereign citizens love all this nonsense talk about, the sig of the circle twice cut, whatever that even is, thinking that by uttering these magic words they will be immune to the law. Well, let's see how that worked out for Mr. Patron. So the court attempted to analyze his legal argument, saying that he appears to claim immunity or exemption from the criminal law under clauses 1 and 63 of the Magna Carta. Those clauses respectively guaranteed the freedom and rights of the English Church, which, as the court rightly points out, at that time was simply the English branch of the Roman Catholic Church, ruled at that time by Pope Innocent III. And the other section provided for the election of 25 barons to ensure King John's compliance with that agreement. The wording of the application of Mr. Patron's refusal to engage and abide by court protocols, again, that is very typical of sovereign citizens, that they refuse to behave like civilized people in court. They like yelling a lot and speaking out of turn. The judge points that out as well, saying that this is typical of persons who subscribe to a nonsensical script and belief that they are somehow immune from the laws which apply to the rest of us. So the court then goes on to review this phenomena a bit, and I recommend you read the case because the court goes through numerous decisions showing where these sovereign citizens, freemen of the land, etc., have lost, and lost in impressive fashion. As they say at paragraph 11, courts have consistently rejected these outlandish claims. So they cite AVI and MHVB 2020 ABQB 489, talking about this pseudo-law. Says it's a collection of spurious, legally incorrect ideas that superficially sound like law and purport to be real law. In layman's terms, pseudo-law is pure nonsense. He looks at another case, Galati in Canada. That's the federal court. So it says, Magna Carta is not a constitutional instrument. While its seminal place in the development of our constitutional legal principles is well known, its terms may be and have been displaced by the legislation of Westminster and Parliament. He goes through a number of other cases. I'm not going to go through all these, otherwise this video will be half an hour long. But as we see, from these decisions, I conclude that Mr. Patron's reliance on the Magna Carta is misplaced. As important as it is historically in the development and expansion of rights and freedoms we now take for granted, it has been supplanted by modern law. And even if it hadn't been supplanted by modern law, Mr. Patron is not the Church of England. He's not the Roman Catholic Church. He's not a cleric of the Roman Catholic Church. So he can't claim immunity from the law by the provisions that he was citing there. Now, as I said, this went to a jury. The jury convicted him. Apparently his defense was, you can't prove I was talking about the Jews, as well as a bunch of his pseudo-law nonsense, which the Court of Appeal mentions he was trying to talk about that and upset that the trial judge didn't instruct the jury on that. But now we have the sentencing decision, so let's look at what happened there, because I think that's important as well. So we look down, starting at paragraph 19, the court points out the maximum penalty under section 319 is 2 years imprisonment, and that there's no sentencing range or starting point established by the Court of Appeal for Saskatchewan. He notes that the Crown Attorney is asking for a year in jail and then looks for a number of decisions. Here's Her Majesty the Queen in Kreplin 2021 ONCJ 19, so a 2021 decision from Ontario. An individual put up some posters that were promoting hatred against Jewish and black people. And the two accused, 23 years old, no prior criminal record, court sentenced both men to conditional sentences of 6 months of house arrest and 2 years probation with 240 hours of community service. Her Majesty Queen in Sears, 2019 ONCJ, two accused are found guilty for promoting hatred against Jews and women arising from publications in a community newsletter. Mr. Sears was given 6 months on each count, and Mr. Germain, who was 78 in poor health, was sentenced to 18 months probation. The court looked at a couple other cases from BC. Topham, elderly individual, 7 years old, 6 months of house arrest. Mr. Patron declined to speak or answer questions at the sentencing hearing. The court went on to talk about how this is such a serious crime. Willful promotion of hatred is a serious offense because it attacks and undermines tolerance. Tolerance is both a virtue and a basic Canadian value. Then at paragraph 62, the court says, taking all the factors and circumstances into account, I conclude that the sentence recommended by the Crown of 1 year imprisonment is appropriate. However, I will limit the following term of probation to 1 year rather than 2 years requested. The 1-year sentence was upheld by the Court of Appeal, although he had already served the entire sentence by that point, so it was a bit moot. But I think it's important to be aware of what type of sentences are starting to be handed down for these cases. As we looked last week, if you're attacking people of European ancestry, you may not be worried about getting a 1-year jail sentence. But if you do a video like what Mr. Patron did, you can be assured that you'll be getting a sentence in that range. So that is something very important to keep in mind. Now, as I said, I'm still not satisfied that this was a rightful conviction. As I discussed in episode 16, the language used by Mr. Keegstra in the Supreme Court decision was much stronger and more direct than that used by Mr. Patron. The court only upheld sections 318 and 319 because of the definition was so narrow. Yet the definition, we don't know how the jury interpreted it. The jury appears to have broadened the definition, but this case is really of no precedential value in determining what constitutes hate crime because it was a jury decision. I think this really needed a judge, because a judge would be required to review the law and rule within the law and would have been subject to an appeal if he didn't. I don't know what his instruction was, because Mr. Patron didn't appeal on that basis. Essentially, Mr. Patron seems to have put all his eggs in the sovereign citizen basket, and that ended with predictable consequences. This video, of course, is not legal advice. If you need legal advice, call a lawyer. You can call another lawyer or myself. My contact information is below. We're also always open to show recommendations, ideas of things you'd like to see me cover. You can send an email to email address listed below. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media. And again, if we get to 10,000 subscriptions on YouTube by the end of the year, I will regrow my handlebar mustache.